Where were we, Mr. Rees?
Good afternoon. Thank you, my lady, my lords. We were in the decision of Mr. Andrew Henshaw QC. I think I was at paragraph 116. If I may now refer to paragraph 117, which makes the point in respect of Walford and Miles, which my learned friend Mr. Gledhill made this morning directly by reference to the authority. And then if we could turn to paragraph 124, which is on page 46, because up until now we've been dealing with the express obligation of good faith. In paragraph 124, the learned judge says that Astra alternatively alleges a similar obligation arose as an implied term of EA2, and says that is, in his view, also unarguable for two reasons. First, it's because it would be inconsistent with the express terms of EA2 for the reasons given in paragraphs 114 to 116 above. So, in other words, the judge is relying upon the same reasoning as in respect to the express term that I've gone to. And then secondly, the judge says that there's no arguable grounds on which the term should be implied, applying the test set out in the case law, and goes, of course, to the leading authority in that context now, the Marks and Spencer's case in the Supreme Court, sets out the test from the Marks and Spencer's case. We go over to paragraph 127. The judge's conclusion is quite apart from the point that the proposed implied term would be inconsistent with the express terms of EA2. It is unnecessary in order to give business efficacy to EA2, which is perfectly coherent commercially and practically without it, and it's not so obvious that it goes without saying. EA2 is a straightforward exclusivity arrangement whereby the selling party, in consideration of the work done by the counterparty with a view to entering into a purchase contract, agrees for a limited period to refrain from offering the asset to or soliciting interest from any third party. It is neither obvious nor necessary to imply into such a contract an obligation to negotiate in good faith, the effect of which would be to preclude either party from walking away or seeking a price variation at their discretion, especially, though not only, when the agreement envisaged ongoing due diligence. On the contrary, it is perfectly consistent with an exclusivity arrangement for each party to retain the right to do so. For these reasons, I conclude that Astra's claim, based on a breach of duty of good faith, has no real prospect of success. We rely on this case as being on all fours with the one which is under appeal. It is a case where there was ongoing due diligence. It is subject to contract. The implication of an implied term of good faith would be inconsistent with any terms of the exclusivity agreement which have been agreed. So, insofar as it were necessary to refer to authority for the point, we say that this is a authority which should be applied and endorsed.
And that's what an alternative formulation in that case was the anticipated contracts that do not materialise.
Yes.
Unjust enrichment, and that claim wasn't struck out.
No.
On the same facts.
No.
And it may be that is really what the gist of the argument, the contention is here, although not pleaded or advanced.
Well, indeed, my lord. If that was a case that was going to be put against my client, it would have had to be put back before the judge at the initial hearing. And I should stress, the court's obviously been addressing the amended particulars of claim. These points as to the deficiency of the pleading are not ones which were taken by way of surprise or ambush at the hearing. There are detailed defences from, certainly from my client, from the Bonhams defendants, from the Lohomij defendants. In fact, the only party that didn't file a defence was Mr. Brooks, because he moved straight for summary judgment. And in response to the summary judgment and strikeout applications was produced the amended particulars of claim, which didn't seek to address the deficiencies in question, such that you are not being troubled with the allegation which was made, for example, against my client and against Mr. Brooks. There were claims of deceit which were pleaded, which were hopeless and were struck out because they were not even arguable on the pleading. They were not coherently pleaded claims in fraud. So, for better or for worse, the position which the claimants have taken is to stick to their guns. The amended particulars of claim essentially only deal with adding an implied term argument for the purposes of the post-settlement causes of action. So I don't seek to deny that there may be alternative ways in which a claim could be formulated against my client and against other clients, say other defendants, and if that was, we'd have to consider them and we would have sought to deal with them. But on the claim as pleaded, there simply is no arguable cause of action in respect of either fiduciary duty or breach of contractual duty of good faith. And we say on that basis that there's no reason to disturb the judgment of the learned judge below.
I think the importance of unjust enrichment claim is that you don't have to strain here to find good faith or breach of fiduciary duties to avoid unfairness in this type of situation, because there is a restitutionary remedy if a party has been led into a particular path in anticipation of a contract which doesn't materialise, or at least a potential remedy.
Yes, my lord, I see that, and without wishing to trespass too far into it, because I should make clear that this is not something which has been advanced against us previously. No. But what we would say is that, and the judge said, and it's a point I'll come to actually in relation to something we raised by way of respondent's notice, that this is a pretty extraordinary type of allegation anyway, because it is a complaint in relation to an agreement which ultimately MRL entered into. MRL entered into the commercial agreement, which gave them a very substantial benefit. But for the commercial agreement and the associated facility agreement, MRL would not have been able to, on their case, have bought the Stella Bar collection, would not have been able to sell the Stella Bar collection at auction, and would not have been able to sell the other cars via auction at Goodwood and private treaty sale subsequently. So they benefited from it, and they do not seek to advance any claim to set aside that agreement. They're beneficiaries. And so one of the points which the learned judge made was to say that this is incoherent, not least because it's an agreement which they ultimately entered into and don't complain about. And also, insofar as there was an exclusivity agreement, that's been superseded by the commercial agreement, by the facility agreement, and then thereafter by the settlement agreement. So there's a chain of contracts of which no complaint is ever made seeking to set it aside. So we would say that there's no injustice here at all to get an unjust enrichment claim off the ground. Ultimately, if there was going to be any claim which MRL was going to make, they would have had to seek to make a claim in economic duress. And they've shied away from making that claim. They don't make it, they've not made it below, it's a point that's been made to them below, it's a point that's been made by my Lord Justice Phillips in this court, and they have resisted saying that. And I think it's quite deliberate. They suggest in their pleading that they were forced to enter into the commercial agreement, but don't say that they had to enter into it under duress. So we would say that in those circumstances there wouldn't actually be an unjust enrichment claim. The unjust enrichment claim would only be legitimate if they had not entered into the commercial agreement at all. And indeed, the situation in Astra, where there was no agreement, Astra pulled out and then sued for breach of the exclusivity agreement. My Lord, my Lords and my Lady, I referred to our respondent's notice because we do take 3 additional points there in relation to the breach of the alleged owing of a duty of good faith, which are supplementary points. I don't need to press them, I think, particularly with great force, because we say that the starting point is that it's unarguable for the reasons already given. But insofar as it is necessary also to pursue them, my client's respondent's notice is at tab 4 in the core bundle. And the part that I rely on is at page 80 in the bottom right-hand corner. And this paragraph 2 that begins on page 79, the parts that I'm going to refer to as C and D on page 80, essentially what we say by way of respondent's notice at this part is the judge had before him a claim for breach of contract. The claim was in respect of breach of the alleged exclusivity agreement. And the judge dealt with that claim in quite some detail in his judgment and dismissed it. And MRL, we say quite rightly, have not sought to revive that case on appeal. But the reasons that the judge gave for rejecting the exclusivity, breach of the exclusivity agreement claim, apply equally to a claim for breach of duty of good faith. So we say that they also apply, and they are supplementary reasons which the judge could have given for rejecting the breach of duty of good faith claim. The first one, paragraph C, we say the judge correctly held that the 22nd of May 2014 email cannot be reasonably construed as evincing an intention to create legal relations in respect to the acquisition and sale of the collection. And this is, we refer there to paragraphs 127 and 128 in the judge's judgment. That's at tab 11 at page 253. The judge refers to subject to contract and the due diligence process, but we place particular emphasis on the point in relation to sufficient certainty in respect of a period of exclusivity. That's paragraph 128. And here we rely gratefully upon Mr. Gledhill's observation in relation to Walford and Miles and the period of exclusivity in that case. We say the judge was right to reach the conclusion here. We deviate from Mr. Gledhill only in this regard, that he said it wasn't necessary to address this. We say that it might be necessary because we rely upon it for the purposes of an additional reason why we say this claim should be dismissed. The next point that we rely upon in order to say that the judge was right to dismiss the exclusivity agreement and it applies equally to the contractual duty of good faith is his back. I apologise for jumping around. Tab 4, page 80. We say that additional reasons for rejecting it are that, in subparagraph D, the alleged obligation on Bonhams to buy the collection is inconsistent with an express term, the 22nd of May email. I've already addressed the inconsistency between a term of exclusivity and an alleged obligation to buy the collection, or alleged obligation of good faith, which amounted to an obligation to buy the collection. We also say that the 22nd of May email, as the judge held, clearly envisages MRL buying the collection and then Bonhams selling the collection for MRL. If that is right, it cannot possibly be the case that there was at one and the same time an implied obligation for Bonhams to negotiate with MRL to do a different transaction, to buy the collection. If we are right on what the 22nd of May email says, and we endorse what the judge held in that regard, it cannot be correct to say if the 22nd of May email expressly concerned a transaction for loan, it can't be right to say at one and the same time there was an obligation to negotiate the sale contract instead. The final point we make in this regard is the supersession point, which the judge made. And this is Roman 2 on page 81. The 22nd of May email did not give rise to any argument in respect to Bonhams acquiring the collection. That purported agreement was superseded by the facility agreement, whereby Lohomij agreed to lend money to MRL so that MRL could purchase the collection itself. I don't think we need to go to the judgment, I hope, because I've quoted the relevant sentence in the respondent's notice. Having done so, MRL can hardly complain that Bonhams was in breach of contract for not proceeding in accordance with the prior agreement that its own contractual arrangements with Lohomij had superseded. And then for good measure, that purported agreement was also superseded by the commercial agreement. And we point out that MRL does not specifically challenge these findings on appeal. Now, it's right, in fairness to MRL, to say that they don't need to challenge those findings on appeal, given they are not raising the or seeking to resurrect their breach of exclusivity contract claim. But we put in this respondent's notice. It's not been addressed by way of skeleton argument. Mr. Fenwick has not addressed it in all his submissions. We therefore invite the court to treat the matter as it stands, which, as we say, the judge's judgment was correct for the reasons he gave in that regard. Those reasons, we say, logically apply to the breach of duty of good faith claim, and in the absence of any specific challenge to the judge's reasoning, we respectfully endorse it and say that it is a supplementary answer why the breach of duty of good faith claim doesn't work. If I may now turn to the final section I wish to deal with, it's ground 6. And I need to be very, very clear here why I'm addressing ground 6. And this is, there is a potential scenario, the outcome of this appeal, a potential scenario whereby MRL succeeds on ground 1, on the settlement agreement point, and MRL succeeds on ground 6, the post-settlement causes of action point. In that scenario, MRL would be entitled to bring a conspiracy claim, and it would be entitled to bring a claim in conspiracy which covered the post-settlement agreement period. It would be available to them under ground 6. Now we say, in those circumstances, there still would be no claim against my client, Mr. McLean, in conspiracy in respect of the post-settlement agreement period. This is not academic or contrived, I hope. The method in my madness is, it would be a very unfortunate result for my client if that transpired. If my client was then given the news that he had to attend a trial in 2 years' time dealing with the post-settlement agreement period, I'm sure my client's immediate question to me would be, well, why? Because I had absolutely nothing to do with that. You know I had nothing to do with that. And the short point is, because a claim has been pleaded against my client in respect to the post-settlement agreement period, I have to deal with it. It is not a claim which should have been pursued. It has been pursued. It's still there on its face. It's not, in fact, been struck out by the judgment below on any separate ground other than knocking out the conspiracy claim and knocking out the post-settlement agreement causes of action. So it still could, in theory, come back to bite my client. It is an extraordinary claim to make against him for at least the following reasons. In the period after the 31st of July 2015, that is after the settlement agreement, he is not alleged to have committed any unlawful act. There's a conspiracy claim against him, but with the curious feature that he's not alleged to have done anything himself that's unlawful.
Why does that matter? He's party to the conspiracy.
It matters. My Lord, I completely accept that it's an arguable claim in law. There's not a formal defect in law. The reason it matters, and there's a passage in the judge's judgment below which refers to this, is ordinarily, in order to determine whether somebody is party to a conspiracy, one looks at the unlawful acts. That's a case called Bird and O'Neill, I think, in the Lords early last century. And so one looks at unlawful acts in order to see, well, has that person been part of the conspiracy? On the basis that conspirators very rarely record their agreement or understanding in an email and send it to each other.
But on this basis, he was party to, was alleged to be party to the earlier unlawful acts. So one doesn't have to be party to all the unlawful acts.
Indeed, my Lord, but as if I may, I will come to, it doesn't make sense, the allegation of conspiracy against him, because at the time he's alleged to have entered into the conspiracy, the objects of the conspiracy in the post-settlement agreement period couldn't possibly be known to him. It's an incoherent allegation. It's essentially, he's alleged to have agreed back in, I think it is in May 2014, he has agreed to do things which he could not have known about in May 2014. It may be helpful if I make that point good by reference to the pleading. The combination in the particulars of claim is, so the particulars of claim are at tab 16 in the core bundle, and the combination is pleaded in paragraph 117. Sorry, that's paragraph. So I apologise. It's paragraph 395.
Sorry, I'm slightly lost. So
Page 395. I
Thank
do
you.
apologise. page 395. There is one combination pleaded. That's the point which Mr. Glethill previously made. There's only one combination. It's not a combination pleaded pre- and post-settlement agreement. And this combination is that from at least May 2014, there was a conspiracy to injure MRL, although in fact it's actually an unlawful means conspiracy, to auction 10 cars in California, that's pre-settlement agreement, to prevent MRL from repaying the sums under the amended facility agreement. Well, that's post, but that can't possibly be something that any of the alleged conspirators knew about in May 2014, because they don't know about there's going to be an amendment to the facility agreement in light of a settlement agreement. Then paragraph 3, subparagraph 3, following MRL's letter before action dated 13th of April 2015 to destroy Mr. Sullivan and therefore MRL, so it appears to be suggested that after the 13th of April 2015 there is an intention to destroy Mr. Sullivan and MRL. And again, that's not something which could have been envisaged in May 2014. And then it's alleged in subparagraph 4 that there's a conspiracy to facilitate Lohomij direct his sales of the remaining cars to associates at less than the true market price. Again, that can't be envisaged in May 2014 at the time when all that has been agreed, if anything has been agreed at all, is an exclusivity arrangement in relation to a potential loan transaction for the sale of cars at auction. So the combination that my client is alleged to be party to only works in respect of the pre-settlement agreement period. This is also true, it's emphasised by paragraph 121 on page 399. My learned friend Mr. Collins was addressing this paragraph shortly before lunch, and he made the entirely correct point, if I may say so, that subparagraphs 1 to 4, these are the unlawful acts pleaded, subparagraphs 1 to 4 are all pre-settlement, subparagraphs 5 to 8 are all post-settlement. The problem about pleading this as a conspiracy claim to one combination is that none of the defendants, but including my client, none of the defendants could have known about a settlement agreement in May 2014. There hadn't even been a commercial agreement in May 2014, let alone knowing that there would be a dispute about whether it was breached and other allegations made in the settlement agreement would be made. Breach of an amended facility agreement, well, there isn't even a facility agreement in May 2014, let alone an amended one. Procurement of breach of a settlement agreement and or amended facility agreement, again, fails for the same reason. And then conversion of the ABARTH, which is not something which is alleged that my client had anything to do with anyway. So I'm afraid we say that this is not a claim that ever on its face made sense. And as we said in our respondent's notice, that in itself is reason why the post-settlement agreement conspiracy claim should fail against all the defendants. MRL would still, in theory, if it succeeds on ground 6, be able to pursue a claim that Bonhams and Lohomij committed individual unlawful acts that weren't part of a conspiracy. But insofar as it is alleged that all the defendants are party to a conspiracy, that, we say, is not a coherent claim because it's based on a single combination. And as my learned friend Mr. Gledhill said yesterday, the judge specifically ruled on the single combination point, that's paragraph 121 of his judgment, and he held there's only one combination and only one conspiracy that's ever been pleaded. And MRL challenged that, or sought to challenge that, by way of applying for permission to appeal from the learned judge below, and that is in the core bundle, tab 13, page 351 in the bottom right, paragraph 9, said the judge also urged in rejecting the submission that even if the settlement agreement precludes the claimant from advancing claims based on matters predating the date of the settlement agreement, it is nevertheless entitled to rely on unlawful means employed after that date in support of an allegation of unlawful means conspiracy. And then over the page, there are 5 different reasons given in sub-paragraphs as to why it is said the judge got that point wrong. There was a challenge made to the judge about that. And the judge, we say, with respect, entirely properly and forthrightly dealt with that point when he refused permission to appeal. And that is found at tab 10 in this bundle, page 181. Paragraph 4 at the bottom of page 181. Judge gave this appropriately short shrift. Said the third ground, post-settlement conspiracy, has no merit. Only one combination in conspiracy was pleaded, and it was within the scope of the release. The result is not perverse, because any freestanding wrong committed after the deed of settlement could ground a cause of action. Further, the claimant has not shown that it is reasonably arguable that any conduct after the deed of settlement was capable of constituting unlawful means. Therefore, the ground goes nowhere. So the judge refused permission on that ground and gave properly the reason for it. And MRL didn't renew that when they renewed their application for permission to appeal to this court. It's probably irrelevant, but one surmises, of course, that that was a deliberate decision, that having seen what the judge said, that a sensible decision was taken, that it was not something which was going to be reasonably arguable, so as to get permission to appeal. So MRL are the author of their own misfortune. They pleaded a claim which is, we say, not coherent in respect of post-settlement agreement conspiracy. They decided not to amend it. The judge has dismissed it in his judgment on account of there only being one combination pleaded. No attempt was then made to amend in order to bring it before this court. And indeed, no application for permission to appeal was made to this court. So we say that, at least as regards conspiracy in the post-settlement agreement period, that's not a viable claim, and it should be dismissed. But we also say, separately and in addition to that, that if I'm wrong about that, and ultimately if we were in a position whereby, my lady and my lords, you were minded to allow a claim to proceed in respect to the post-settlement agreement period in conspiracy, so if we're in the scenario where MRL succeeds on grounds 1 and 6, we say there's no claim available against my client, and we say there's no claim available against my client because there is no claim which has been properly pleaded in fraud and which would have a real prospect of success. And we say that for the reasons set out in our respondent's notice at paragraph 3b, which is at tab 4, page 82. Again, this is the point, obviously, we pleaded by way of respondent's notice, so it's right to say that MRL wouldn't have anticipated it in their own skeleton argument, but it's not been addressed by any supplementary skeleton argument, nor in oral submissions. We say that, first of all, MRL does not allege in that period that Mr. McLean committed any unlawful act, was involved in any misconduct, or assisted any other defendants. See, that's susceptible of any dispute. The judge correctly held, and this is paragraph 159D of his judgment, the alleged purposes of the conspiracy in the period after 31st July 2015 can have nothing to do with Mr. McLean. And then he separately held at subparagraph 163C, the particulars of intention to injure in that period cannot relate to Mr. McLean. And then in the paragraph 171 of the judgment, the judge held no part of APOC, the amended particulars of the claim, can reasonably be construed as advancing any claim against Mr. McLean personally in respect to the period after the settlement agreement, save in respect of conspiracy as to which see above. So this is, with the greatest respect to the learned judge, this is the one point in the judgment that we do take issue with. And certainly we don't criticise the judge for it. It was a conspicuously detailed and careful judgment, but it is a point which we respectfully disagree with, which is why it's properly part of a respondent's notice. We say that the judge should have concluded there is no proper claim in respect to Mr. McLean in the post-settlement agreement period, because he's not alleged to have done anything which is unlawful in that period.
One of the difficulties I've got in understanding and assessing how this comes about is that I don't think we've either got your application notice, nor do we have any statement from Mr. McLean.
Right.
So yes. I don't really know how one can see whether this was part of the strikeout and how it was put in order to criticise the judge for not dealing with it.
Yes, my lord, that's well, I apologise. That's entirely fair. It's not in the bundle. It's not in the bundle. These are not points which have been taken against us by MRL. It's not been suggested by MRL that these are not points which are not available to us.
Well, there are so many points in so many alternatives, but I have to say that actually understanding what actually is or is not. I mean, I don't know whether you did specifically say that you wanted to strike out on this particular hypothesis or not.
My lord, I would have to look at the detailed skeleton argument and the application grounds, which I don't have before.
Well, how can you pursue a respondent's notice that the judge didn't deal with it if you can't even tell me that it was before him?
Well, my lord, we certainly made the point below. We made a general overarching point that the claim should be dismissed because it wasn't a properly arguable claim in conspiracy against my client because he wasn't involved in the unlawful acts. That's the burden.
As I understand it, there is one. You make the point there was one conspiracy alleged to injure MRL.
Yeah.
And the broad thrust of it was, at least initially, in relation to the way the transaction was structured and what was to be done in relation to the sale of the cars.
Yeah.
And that then evolves, as I understand it, into the way that the sale of the cars was thereafter dealt with. Once somebody is party to a conspiracy, and in particular by participating in unlawful acts, they remain responsible for, liable for that conspiracy, unless and until, for some reason, it can be shown that they cease to be part of the conspiracy.
Indeed.
Now, I haven't seen any evidence from Mr. McLean explaining what his role was, or why, or what his dealings were with these parties after 2016. You may tell me he had none, but where's the evidence of that?
Well, Lord, there was evidence below, but what we do rely upon is what the judge held himself in the judgment, which is not in dispute. If I may take my lord to.
Well, I don't see the point of doing this if we don't have the application and don't know the way that this application has been put.
Well, my lord, we say it follows from the paragraphs in the judge's judgment that there's no proper claim in conspiracy against Mr. McLean. So, in other words, the logical consequence of what the judge has held is that there can be no claim in conspiracy against Mr. McLean. But I'm not inviting the court to look at Mr. McLean's evidence, of course, and say, as a consequence of what Mr. McLean says in evidence, the judge should have concluded this. And that would be a difficult argument to advance in this court on the basis of primary witness evidence and not be tested in cross-examination. I don't seek to do that. What I seek to do is rely upon the findings that the judge made, which are not in dispute on appeal. They've not been challenged on appeal. And say, as a consequence of those findings, there's no arguable claim of conspiracy against my client in respect of the post-settlement agreement period. So, if I may, the paragraph 9 of the judge's judgment, he says, and it's at tab 11, page 189. This is where he introduces my client. Says the seventh defendant, Mr. Anthony McLean, was the non-executive director of Bonds from the 11th of April 2002 until the 8th of June 2016. During that period, he didn't have responsibility, and it goes on. From 2014, he also provided assistance to MRL as a consultant in respect of efforts to sell some of the cars. After July 2015, which is a significant date in this case, of course, because it's the date of the settlement agreement, his only involvement in respect to the cars was in acting for and on behalf of MRL. Mr. McLean has never been a shareholder in Bonhams or any of its associated companies or any of the companies within MRL. So that's the first paragraph on which we rely in that regard. And the other ones are at paragraph 159D, which is at which is page 268, in which the judge addresses the purpose of the conspiracy. It says purposes 2, 3 and 4, they're the post-settlement agreement purposes that we looked at earlier in the pleading. Purposes 2, 3 and 4, the judge says can have nothing to do with Mr. McLean. And then 163C, same section, judge is looking at the particulars of intention to injure, which I earlier addressed the court on. It says particulars 5 and 6, but it says matters of the settlement agreement, they cannot relate to Mr. McLean. As explained below, they have no merit anyway. And then paragraph 171, the judge says, page 272, just under the heading post-settlement agreement causes of action, no part of APOC can reasonably be construed as advancing any claim against Mr. Brooks or Mr. McLean or Mr. Luman personally in respect to the period after the settlement agreement, save in respect of conspiracy, and the claim against Mr. Luman for conversion which is accepted ought to go to trial. So what we say in relation to those 3 paragraphs is what they amount to doing is saying there is no claim as pleaded against Mr. McLean in relation to the post-settlement agreement period, other than the claim in a conspiracy based upon the combination in May 2014. And we say on that basis, it is the logical consequence of the judge's own findings that there is no claim in conspiracy against Mr. McLean in the post-settlement agreement period.
We're a little bit careful about this, haven't we? Because I think the purpose of a conspiracy is to injure. That's the only purpose that needs to be alleged, isn't it? And that's the whole point, because in some conspiracies to injure, you've got to show that the purpose of injuring was the dominant purpose. Where you've got unlawful means you don't need to show that. But nevertheless, what is pleaded is that this is a conspiracy to injure.
Well, it's not pleaded as a conspiracy to injure in the sense that a lawful means conspiracy.
No, it's an unlawful means conspiracy to injure.
Yeah.
But you don't need to have, it's not necessary to identify the sub-purposes or that all the conspirators were party to those sub-purposes.
But you have
what you have to show is that there is a conspiracy to injure by unlawful means, and that somebody who is party to that conspiracy is liable for the entirety of the conspiracy.
But the acts have to be within the scope of the combination. So the unlawful acts which are pleaded, or the unlawful means which are pleaded, have to always be within the scope of the combination. Otherwise, one could have a situation in which parties reach an unlawful combination, and anything they thereafter do together is deemed to be part of the same conspiracy. And that's why, in this case, the claimants have pleaded what they say are the acts within the scope of the combination.
But on the hypothesis that the appeal succeeds on grounds 1 and 6, your client's going to be part of any trial, isn't he?
But only in one narrow respect, my lord, which is assuming, actually, it depends. That's my point. Sorry, is incorrect. It entirely depends upon how my lady and my lords address the other grounds of appeal. If it is the case that there is no success in respect of grounds of ground 2, the fiduciary duty and the breach of duty of good faith claim, then the only respect in which my client would be party to a trial would be in respect of the claim against Bonhams and Butterfield for the unlawful conduct of the auction, which is, I think, paragraph 170 of the judge's judgment, where the judge held that that claim was just about arguable. In that circumstance, my client would have a very narrow involvement in the trial, because my client's case, but I'm not inviting the court to reach any finding on this, I can't, but my client's case is that he wasn't involved in the auction at all. It wasn't his job. He's not an auctioneer. He wasn't involved in arranging the auction. He did attend the auction, but only in an observing capacity. He didn't have anything to do with it. It was done by Bonhams and Butterfield, and also Bonhams in England, and they were the ones who organised it. So, in theory, my client would be party to a trial in that respect, although I imagine that the point would be rather forcibly made in correspondence that there's no basis of retaining him in such a trial, because there's no proper claim that would be made against him.
We're dealing with a strikeout here.
Sorry, I didn't hear that.
Dealing with a strikeout.
Yes, yes. I'm not inviting the court to dismiss the claim on that ground. What I was addressing is that my Lord's question was, my client will be party to a trial in any event, to which I respectfully agree, but say that it would be a very narrow trial. It wouldn't be as if my client was there facing all the allegations which are made against Lohomij and Mr. Lumen and Bonhams in respect to the post-settlement agreement period. That's the purpose of it. What I'm keen to seek to establish, and I appreciate in a way I'm tilting at a windmill or a hypothetical, because it depends upon how the chips land from the points that have been argued. But what would be unfortunate, we say, for my client, is if he were forced to stay in proceedings up and until trial in respect of the post-settlement agreement period, when on its face nothing has been pleaded that he did anything wrong. For some part of the period he was acting as MRL's own agent, seeking to sell MRL's cars, and has brought a counterclaim seeking the money which he says is due to him as a result of doing that. And the judge has held that he didn't do, if I may paraphrase, he didn't do anything wrong in that period. We say in those circumstances there's no arguable claim against him in respect of that period based upon what the judge has himself held.
And the paragraphs are 159D, 163 and 171.
And paragraph 9 as well.
And 9.
Yes. And they're all the paragraphs.
On what he says there.
Yes. Thank you. Sorry, my lady. Unless I can assist the court further, those are my submissions.
Are you appearing alone today in this appeal?
I'm leading Mr. Christianji.
Ah, I see. He's just not on it.
He's not on the list.
Not on the list.
Oh, sorry. I apologise. And I'm sure Mr. Christianji would have indicated to me if he wished to follow, but if he does, I'll be as interested as the court to find out what he has to say.
We have some specific questions for him, which is why we needed to know his name, particularly. Lord Justice Arnold? Thank you very much indeed, and thank you for keeping to time.
Thank you very much. Thank you, my lady.
And so we now move on to Mr. Colton.
Thank you, my lady. I'm leaving the absent Mr. Ishwega, which you'll see his name on the skeleton, but he's not able to be here in person. I will be addressing the court briefly on grounds 1 and 3, but using most of my time on ground 6. And on ground 1, I just wish to correct some submissions of my learned friend Mr. Fenwick insofar as they relate to my clients. It was suggested that it was Lohomij which initiated its involvement in the settlement agreement in circumstances where no claim was made against Lohomij in the letter before action. Mr. Fenwick said there was no obvious reason why Lohomij was even party to the settlement agreement. But that's not right. It was MRL itself which first suggested that Lohomij might wish to be involved in the settlement agreement in the without prejudice letter that Spring Law sent on the same day as the letter before action, the 13th of April 2015. If I might just show the court that, please. It's supplementary bundle, tab 15, page 134. And on that page, just above the heading Current Position, it says, we set out below 2 alternative options, which MRL would agree to settle all claims present and future, fully and finally with Bonhams, and Lohomij BV to the extent required and or requested by Lohomij BV, for the purpose of this letter, etc. And indeed, it was Mr. Sullivan of MRL himself who provided the letter before action to Lohomij after a meeting with Lohomij's representatives. I don't need to turn that up, but that's in Mr. Sullivan's evidence at paragraph, it's his first statement at paragraph 107. The reference is Supplementary Bundle, tab 25, page 204. And moreover, as my learned friend Mr. Gledhill has shown the court, the spring law letter, the open letter, which is in tab 14 of the supplementary bundle, plainly did implicate Lohomij in allegations of wrongdoing. The court has been taken through that letter twice, so I'm not envisaging doing so again. I was just going to draw the court's attention to two particular passages. The first is a passage that has already been seen on page 129, which is the reference, it's just above little Roman 1, to the unique circumstances of a transaction whereby a significant shareholding in Bonhams is held by the same beneficial owners as Lohomij, MRL's secured lender. And then, at page 131, a passage which I don't think has been read out, the fourth paragraph just below little Roman 4, the first unindented paragraph, we're aware that during the period of late spring and early summer, Bonhams were seeking bids to acquire the company. It's quite obvious the guaranteed fee income from selling valuable items without reserve, together with the increased publicity of holding the auction in the USA, was hugely beneficial to Bonhams at that point in time, in terms of increasing or preserving its own valuation and its attractiveness as an acquisition target. So having made the point that Bonhams, a significant shareholding in Bonhams, was held by the beneficial shareholders of Lohomij, they then suggest that deliberate wrongdoing took place in order to bolster the value of that shareholding. As I say, I'm not going to go back through this letter generally, and it's fair to say, as has been said before, that there's no specific cause of action which is identified against Lohomij in this letter, but it clearly spelled trouble for Lohomij on the horizon. The reasonable recipient of this claim, this letter, having been given it by Mr. Sullivan, would have thought that MRL might be gearing up for claims against Lohomij, claims alleging deliberate wrongdoing of Lohomij and Bonhams working together. And the parties acknowledge that the reasonable recipient would have thought that there were claims being made, because that's recital E to the settlement agreement. And the court has been shown this before, but just to remind the court of this, it's at tab 16 at page 139, and makes express reference there to the parties having, subject to the terms of this agreement, agreed to settle MRL's claims against the Bonham parties and or Lohomij, and or any of their affiliates or agents. Now, it was suggested by my learned friend Mr. Fenwick in response to a question from my Lord Justice Arnold, that the settlement agreement was itself a dishonest step in the furtherance of the conspiracy against his client. That was page 56 of yesterday's transcript. As I've shown the court, it was MRL who initiated the compromise and invited Lohomij to be party to it. Objectively, just looking at the documents, the rationale for Lohomij's involvement is plain enough. It was to buy off the risk of claims by MRL. That's what MRL invited in the without prejudice letter, and in terms, that is what is recited in recital E. My lady, that's all I was going to say on ground 1. Ground 3 only arises as against my clients if MRL succeeds on ground 1 and ground 2, the existence of a fiduciary duty, and ground 3.1, breach of fiduciary duty. And the judge decided, and I can show the court this, it's in the core bundle, tab 11 at page 261. The judge decided that in addition to the finding that the claim had been settled, there were 3 reasons why the allegation against my clients discloses no reasonable grounds and has no real prospect of success. First, no fiduciary duty owed, and my learned friends have addressed the court on this. This is at 1471. 1472, no proper plea of dishonesty, and that, of course, is a standalone ground on which a claim for dishonest assistance can be struck out. And I'll show the court why his lordship concluded that. And third, and in any case, that the claim was untenable on the facts. And I'll deal with that as well. Dealing with the inadequacy of the plea, we can see the plea, or the first part of it, in tab 16 of the core bundle at page 379. And at paragraph 43 there,
Oh, sorry, tab 16
at 379,
thank you.
paragraph 43, as is set out below, Mr. Brooks and Mr. McLean's actions amounted to a breach of fiduciary duty and or the obligation to act in good faith by both of them personally and also by Bonhams. Lohomij and Mr. Loughman dishonestly assisted with the breach of fiduciary duty. And then we can see further below, page 400 in the pleading, first, the court sees paragraph 123. Bonhams breached the terms of the exclusivity agreement. Paragraph 125. In the further alternative, the change of position by Bonhams between the 27th of June 2014 and 30th of June 2014 amounted to a breach of fiduciary duty by Bonhams, Mr. McLean and Mr. Brooks, and or a breach of the duty to negotiate in good faith, as Bonhams was seeking to profit from MRL having terminated negotiations. And then 126, Lohomij and or Mr. Loughman dishonestly assisted Bonhams in its breach of fiduciary duty by insisting that the sale should take place in California and not London, when it, I think that must mean they, knew that the sale in London would achieve the highest price. Now, insisting that a sale take place in California rather than London, knowing that it would achieve a higher price in London, cannot without more amount to dishonesty. And if there is more, it should be pleaded, but it's not been.
Just to be clear, this is not something that Mr. Fenwick addressed in oral submission.
No. It's a point I think we're making in our skeleton, it's a point that the judge made, but no, it's not addressed in oral submissions.
So I'm not sure whether an appeal is being pursued in relation to it.
Well, if not, well then I don't need to deal with ground 3 at all, because it's a standalone proper case
Normally, if
management.
a party doesn't pursue it, you don't need to deal with it.
Well, okay, in that case, I will, well, I'll deal with the third point anyway, because he dealt with the third point under, on the mini trial point. So I'll deal with the other reason given by the judge, because it also feeds into mini trial. And that's the other reason given for dismissing the claim, going back to page 261 in the core bundle, which is 147.3. The evidence of Ms. Wolff and Mr. Lohomij had nothing to do with the choice of venue for the auction. I can see no evidential basis for gainsaying that statement. And that is a conclusion on the basis that there was simply no evidence to support the plea of Lohomij having insisted on the sale taking place in California. Now, my learned friend Mr. Fenwick did submit yesterday that there was evidence from his witnesses in their witness statements to support this, of Lohomij insisting that the sale take place in California. Well, we can't find that evidence. It's not referred to in his skeleton, and it wasn't referred to while he was on his feet either. The judge here was making an entirely, in my submission, correct ruling, which is if there is literally no evidence to support something, then it lacks an arguable basis. This isn't some shifting of the burden of proof, as it is suggested in their skeleton argument. There's simply no evidence to support it, and what is more, it is in fact denied. That, I think, is all I need to say on ground 3. Turning then to ground 6. This obviously involves freestanding causes of action which postdate the settlement agreement. And what I intend to do is to first remind the court of what those causes of action are and why the judge summarily dismissed them. And then I'm going to approach the appeal by dealing with the 2 issues that are actually set out in MRL's skeleton. The first is the point of principle that the approach adopted by the judge was impermissible. And the second is the question about whether, it's a legal question, whether as a matter of law there is an implied term to be found. And on that latter point, taking the cue from my Lord Justice Phillips, on his feet Mr. Fenwick only mentioned an implied term. I'm going to assume, therefore, that is all that remains live, and not the invocation of common law and equitable principles. So I'm going to do it slightly an unnatural way round by looking at the result first and the procedure second. But I understood from the questions this morning the concerns that the tribunal has in that regard. So the court will be aware that there are 3 so-called sales, 3 planned transactions, known as Sale 1, Sale 2 and Sale 3. And in respect of these 3 sales, MRL were originally alleging that Lohomij's conduct breached 3 contractual clauses, namely Clause 6 of the settlement agreement, Clause 8 of the settlement agreement, and Clause 9 of the amended facility agreement. I'll just show the court those 3 clauses. So in the settlement agreement, supplemental bundle tab 16, page 141, Clause 6 is a non-disparagement clause. The parties covenant with each other for themselves and on behalf of each of their affiliates and agents not to do or say anything which is harmful to the reputation of any of them or which may lead a person to cease to deal with any of them. And Clause 8 over the page, in particular 8.2 was relied on. Each party shall at all times act in good faith in exercising their rights and undertaking their obligations under this agreement in order to ensure that this agreement is fully and properly implemented, and that the parties receive the full benefit and effect of the provisions of the agreement. Now, the judge rejected all claims under Clause 8, and there's no appeal from that, so I'm going to say no more about it. In respect of Clause 6, the judge interpreted this clause, and for the court's reference, this is at paragraph 313(1) of the judgment, as relating to matters within the scope of the settlement agreement. Not an agreement that none of the parties would ever act in a manner adverse to the interests of any other party in any way at any time, but that in respect of the subject matter of the settlement agreement, these parties would not do or say anything harmful to the reputation. On that basis, there were other grounds, but on that basis, the judge rejected all of the claims under Clause 6 of the settlement agreement, because there was no pleaded case and no evidence to support a case that in respect of sales 1, 2, or 3, there was any breach of Clause 6 relating to the subject matter of the settlement agreement, which of course took place a year or more earlier. I should perhaps have given the chronology, which is that June 2016 is when sale 1 begins. It's the earliest of the 3. So it's nearly a year after the settlement agreement. Now, there's been no appeal from the judge's construction of Clause 6. And for that reason alone, the claims in respect of Clause 6, they failed below and they must fail again. Then there's the amended facility agreement, tab 17, page 155. We have clause 9. The borrower acknowledges that the cars comprise charged property as defined in the debenture, and accordingly acknowledges, in accordance with clause 7.2a of the debenture, that no disposition of any of the cars or any other car in the collection shall take place without the prior written consent of the lender, such consent not to be unreasonably withheld. So that was the third of the express clauses, and I'll come back to what the judge did with that. But it then occurred to MRL that its complaint in relation to sale 1 was that MRL had never reached the stage of a disposition of any car. It didn't even claim it had reached the stage of being able to seek consent. So it sought to plead by amendment an implied term, obliging Lohomij not to prevent and or interfere with any prospective sale. So in respect of sale 1 alone, there's that additional contractual obligation which is alleged. I'm aware that the court has already looked at this, but just to orientate the court within the judgment, beginning from paragraph 180 at page 278, the judge sets out the facts under the heading of facts and evidence for each of the 3 sales. And to be clear, these are not findings on disputed facts. By and large, these track MRL's evidence and contemporaneous documents. There is very limited reference to the evidence of the defendants. Having set out the facts in respect of those 3 sales, the judge then, as I've said, rejected all of the claims under clause 6 of the settlement agreement, primarily on the basis of the construction of clause 6. Just for the court's reference, paragraph 316(1), paragraph 317, paragraph 321. That's where the judge deals with individual allegations, but starts or premises his analysis with, even if I'm wrong on the construction, then. And that's one of the points that obviously comes out of this judgment. It's a belt and braces approach, where even though the judge has identified a complete answer, often on the basis of a point of construction, The judge does also then identify additional reasons for the judge's conclusion. That, as I say, was clause 6. Clause 8, as I've said, no appeal, and they were all rejected too. As for clause 9 of the amended facility agreement, this is the such consent not to be unreasonably withheld. Sorry, before I go on to that, I don't know time-wise for a transcribed break what best suits the court.
Yes, that probably is an appropriate moment. Thank you for reminding me. I had completely absorbed. So we'll rise now and we will be back at 17, 18 minutes past.
Yeah. Let's see if this matches its marketing. Let's see if this matches its marketing. I should be able to sing like an opera singer now. Which means the microphone.
Yes, very good. Yeah. 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 It's
All right. We don't seem to have Lord Justice Arnold, so I think we should wait a moment or two.
apologies for the delay.
Thank you. Do continue.
Thank you, my lady. I was going to go then, please, to it's the clause 9 of the amended facility agreement argument, and for this I was going to start by showing the court the pleading of it, the individual sales. So in the particulars of claim, tab 16 of the core, page 386. The court first of all sees sale 1 as pleaded. In June 2016, MRL negotiated sale 1 with FRG, which would have generated. I'm sorry, I shall wait a moment.
I apologise, I'm slightly behind.
Sorry,
I'm sorry, it's page 386
Page 386.
in tab 16. So sale 1, paragraph 69 onwards. In June 2016, MRL negotiated sale 1 with FRG, which would have generated an aggregate sum of 58 million euros for the sale of the following cars. Had this sale occurred, then MRL would have had revenue to repay the loan in its entirety. However, prior to the finalisation of sale 1, Lohomij insisted that Mr. Pius Schlumpf, a director of Bonhams and the Laumann Group, and Mr. McLean meet with Mr. Frank Rickert. At this meeting, Mr. Schlumpf and Mr. McLean told Mr. Rickert and Mr. Schmidt that MRL had a loan arrangement with Lohomij, of which 38 million euros was outstanding, and Lohomij required immediate repayment of the loan, otherwise it would foreclose. At one point in the meeting, Mr. Schlumpf asked everyone to leave the room so that here Mr. Sullivan could have a conference call with Mr. Laumann. On the call, which was on a speakerphone, the discussion became very heated and Mr. Laumann started shouting and screaming at Mr. Sullivan. He told Mr. Sullivan if he didn't get his money back immediately, he, i.e. Lohomij, would foreclose. This was overheard by Mr. Rickert and Mr. Schmidt, who drew inferences, who inferred that MRL was in serious financial difficulties. So sale 1 is not a disposition for which consent was withheld. It's a, because of your conduct, we never managed to conclude an agreement to sell at all. And that conduct is partly said to be the conduct of Mr. Schlumpf in explaining the loan arrangements, and partly Mr. Laumann speaking to Mr. Sullivan of MRL, which of itself can't be objectionable, but doing so, although Mr. Laumann wasn't there, on a speakerphone, which was overheard. That's sale 1. Sale 2, we can then see pleaded, the core facts begin at the next page, paragraph 78, that's 387. In November 2016, MRL agreed sale 2, which would occur in the following sequence. 1, MRL agreed to sell the Ferrari 828 to Mr. Joe Macari in exchange for Ferrari 1953, a Ferrari engine, and a cash payment of £4.75 million. 2, MRL would then install the engine from the Ferrari 1953 to replace the engine in the Ferrari 2025, which was part of the collection and which didn't have its original engine fitted. This would have increased the value of the Ferrari 2025 considerably. And then 3, once the 1953 engine was in number 2025, both of them would have been sold to Mr. Williams and FRG respectively. These sales had already been agreed subject to Lohomij's approval. So that's sale 2. It's a composite transaction, 3 parts to it. And then sale 3, also a composite transaction, is described at page 392. Beginning there, paragraph 101. In June 2017, MRL agreed sale 3, which would occur as follows. 1, MRL would sell 2 of its cars, 818 and 1461, to JD Classics in a deal worth an aggregate sum of £29 million, consisting of a cash payment of £2.5 million and a part exchange of cars worth £26.5 million. MRL would then sell 2 of those part exchange cars for €5 million to FRG, and as a result of obtaining the new cars in part exchange, MRL would be able to agree refinancing packages secured on these part exchange cars. And the breach which we're dealing with in respect of these 3 sales is described at page 405. Particulars of breach. 1, interfering in sale 1, not, the court will notice, refusing to consent to sale 1 because there was no attempt to obtain consent, and it's said to be in breach of an implied term, and I'll deal with the implied term subsequently. 2, refusing to consent to sale 2, and 3, refusing to consent to sale 3. And I should show then the court how the judge dismissed each of these 3 claims under clause 9 of the amended facility agreement. So starting with in respect of sale 1, it's at paragraph 331 of the judgment, which is begins at page 335 of tab 11. And the judge, it's a common theme in the judgment, as the court will have noticed. The judge gives multiple reasons for a number of his decisions. But as regards sale 1, reliance on clause 9 doesn't get off the ground. 1, there was never an actual or proposed disposition to which Lohomij could have consented. And 2, there was never a refusal or withholding of consent to a disposition. Indeed, none is pleaded. 3, MRL has not pleaded that consent was unreasonably withheld, or any basis for contending that withholding consent was unreasonable. which of course follows from the fact that consent was never sought. So that's the basis upon which it's rejected in respect of Sale 1. Sale 2, the judge again gives a number of reasons. And I should have said that the particulars of claim we were looking at, as the court knows, they're the draft amended particulars. I think Lord Justice Phillips used the phrase, the last word, and that's what they are. They're the version that the judge was being asked to consider at the time. Sale 2, paragraph 333, not reasonably arguable. First, as at the 18th of November 2016, MRL was not seeking consent to Sale 2. Sale 2 is pleaded as a composite transaction involving number 828, number 2025, and number 1953. And consent is said to have been refused by Lohomij on the 5th, 11th, 16th, and 18th of November. However, Mr. Sullivan's email of the 17th of November 2016 to Mr. Laumann makes clear that at that date he had only a provisional offer for number 2025, and then only subject to it being restored with its original engine and certified, and had only begun discussions for the sale of number 1953. Consideration of the emails on the 17th and 18th of November, which have been set out extensively above, makes clear that at that stage MRL did not seek consent to Sale 2 in its composite form. What it sought approval for was the sale of, I think that should be 0828, on specific terms, with a view to realising funds from anticipated further sales. Whether or not MRL had actually reached agreements with Mr. Rickett and Mr. Williams for those onward sales, the premise that MRL sought consent on the 18th of November for Sale 2 is demonstrably false. And the judge then goes on to give other reasons in respect of Sale 2. And I'm just, whether one's looking for the knockout blow or the silver bullet or the shortest route, the judge has identified on each case a short, sharp answer, as well as giving other reasons based on the contemporaneous documents. And the court sees that that is based entirely on the contemporaneous documents. Indeed, it's based on Mr. Sullivan's own email of the relevant time. As for Sale 3, paragraph 339, page 338, again, this is pleaded, as the court's seen, as a composite transaction. A sale of both 1461 and 0818 for 29.5 million, payable as 2.5 million in cash and as to 26.5 million as vehicles taken in part exchange, followed by an onward sale of 2 of those part exchange vehicles to FRG for 5 million euros. However, this is not the transaction proposed at the meeting on the 8th of June, which is when consent is alleged to have been unreasonably refused. The only proposed transaction set out in the proposal document was in respect of 1461. In respect of that transaction, the proposal document did not show a cash component of 2.5 million, but only of 2.5 million euros. In respect of that transaction, the proposal document did not show onward sale of the 2 part exchange Jaguars to FRG for 5 million euros. It showed onward sale of 1 Jaguar for 1.7 million euros and guaranteed buyback of the other for 2.5 million euros after 6 months. No putative transaction in respect of 818 was shown in the proposal document, but a completed sale within the preceding 6 months was shown on the final page for a stated price of 16 million euros. No such sale had taken place. So it was common ground that what had actually happened on the 8th of June is that MRL had disclosed that they had actually relinquished possession of one of the cars, which they should not have done without consent, and that was 818. It was shown as having been sold, rather than consent being sought for its sale. So those are the grounds given by the judge for concluding that Clause 9 of the amended facility agreement was not breached. That then leaves only breach of the implied term, the alleged obligation which affects only sale 1 not to interfere with or impede any proposed sale. The judge, in fact, had dealt with this first. He deals with it in paragraphs 303 to 311 of the judgment. In summary, he held that there was no such term to be implied, but that even if there had been such a term, and even assuming that Lohomij's representatives behaved as claimed, it was impossible to see how their behaviour could be a breach of their obligations, or indeed that on the facts, their behaviour had caused sale 1 not to occur. I'm going to come back to this question of the implied term, but the court will have well in mind that my learned friends don't actually challenge the substantive conclusions of any of these points. Their points, and I will deal with that, of course, their point is one of principle about an impermissible approach. And I'm going to turn to that next. So dealing with the impermissible approach argument, the correct approach to a summary judgment application is not in dispute. As MRL accepts in its skeleton argument, this is paragraph 72.1, the judge correctly summarised the approach which the court must adopt on an application for summary judgment. That approach is set out in the judgment at paragraphs 19 and 20. I'm not going to read out those paragraphs, but they show that the judge correctly directed himself as to the approach that he should take. And this isn't just a case of a judge cutting and pasting some standard legal directions into a judgment and then forgetting about them. The judge repeatedly returns to the relevant test through the judgment. Throughout his judgment, the judge explicitly applied a test of reasonable arguability, which, as he explained, was the convenient shorthand for the summary judgment standard adopted by the Court of Appeal in Alsop and Banner-Jones. So that's cited in paragraph 24 of the judgment, and the judge explains he's adopting it in paragraph 25 of the judgment. As I say, I wasn't planning to go through these individual paragraphs unless the court thinks it would be of particular assistance. While the judge does on occasion set out the competing evidence on an issue, the judge works on the assumption that MRL's pleaded case is correct, save in cases where the judge considers that a pleaded case was not reasonably arguable in the context of the contemporaneous documents. And as an example, and this I will show you, please, it's at page 210, paragraph 56. In this judgment, I proceed on the assumption that MRL's complaints concerning the conduct of the auction are correct, though they are contested. Most significantly, of course, for the purpose of ground 6, we have what the judge said at paragraph 173, page 272. I have not conducted a mini-trial. However, the issues on this part of the case turn in large measure on the plausibility of MRL's factual case. Therefore, a critical appraisal of the evidence is required, and it's necessary to refer to the statements of case and the evidence in considerable detail. That is a critical evaluation, to be clear, of MRL's case against the contemporaneous document. One doesn't see a weighing up of whose evidence is more likely to be correct between claimant and defendant witnesses. And I will, of course, deal with the specific examples given by my learned friend when I get to them. I would also add this, in terms of the judge having understood the process and the procedure that the judge was supposed to adopt. If we look in Core Bundle, it's volume 1, it's at tab 10.3, at page 181. The court was actually taken to a paragraph from this earlier. But paragraph 2 here, this is the judge refusing permission to appeal. The first ground is that I inappropriately conducted a mini-trial. This point, said to be an important question of principle, would have teeth only if it resulted in specific conclusions that showed the claims to be reasonably arguable. Now, I accept that, my Lord, I think Lord Justice Phillips disagrees with that proposition, but the judge goes on. Leaving that aside, I consider the ground to be without foundation. I had the correct test and approach well in mind and applied them. The scale of the documentation, submissions in judgment does not indicate that this was anything other than a careful analysis of the issues and evidence for the purposes of applying the summary judgment test. Reliance on witness statements with statements of truth, even from solicitors, does not insulate claimants from the application of the test for summary judgment or strikeout. As to Mr. Walmsley, my remarks on his evidence were both obviously correct in my view, and anyway not central to the reasons given in the judgment for finding the claimant's case to be not reasonably arguable. Ultimately, the distinction between a mini-trial and a proper critical analysis can only be that between, on the one hand, attempting to make findings on the balance of probabilities on the basis of limited evidence, and on the other, deciding what claims are and are not reasonably arguable, in the sense explained at length in the judgment. I did the latter. With respect, that is an impeccable description of the task which faced the judge. And as I shall show, the judge didn't just say beforehand that that's what he was going to do, and he didn't just say afterwards that that is what he had done. One can actually see examples in the judgment that that is what he was doing. So if one's asking the question, was the judge procedurally approaching it properly? Leave to one side the substantive conclusions, but was the procedure right? We would say it is absolutely plain that the judge identified the correct procedure, adopted the correct procedure. Before I then come on to the correct approach to questions of fact or mixed questions of fact and law, I should say something about questions of law in the context of summary judgment applications. Because there's a basic principle at play here. Where the court is in a position to do so, it should grasp the nettle and decide questions of law, which includes, of course, questions of contractual construction or the implication of terms. The Privy Council handed down a valuable judgment on this point last month, which I think I should show the court. It's Royal Bank of Scotland International. It's in Authorities Volume 2 at tab 19. The relevant passage I was going to show the court begins at paragraph 28, which is page 11 of the judgment. This is on appeal from the Isle of Man, but the principles are said to be the same. Paragraph 28, this summary cites and relies upon the judgment of Mr. Justice Lewison in Easy Air. As made clear at paragraph 15.7 of that judgment, where a case raises a point of law and the court is satisfied that it has before it all the evidence necessary for the proper determination of the question, and that the parties have had an adequate opportunity to address it in argument, it should grasp the nettle and decide it. The reason is quite simple. If the respondent's case is bad in law, he will in truth have no real prospect of succeeding on his claim or successfully defending his claim. And I draw attention to the should. It's not merely an option open to the court, it is the preferable course for the court to take. Now, it's sometimes argued, as it is by MRL in the present case, in the context of the sharp practice doctrine in ground 1, that where a summary judgment application is in an area of developing jurisprudence, then it's not appropriate to decide the question without actual findings of fact. I'd only say, I'm not going to take the court to it, but Paragraph 30, I think, deals with this most speedily. This must depend on the extent to which the issue of law is fact-dependent. Where all the relevant facts can be identified, there's no reason why the issue of law cannot be determined, and indeed it'll often be consistent with the overriding objective for that to be done, in the interest, in particular, of saving time and costs. And then their lordships identify a number of examples when that's happened, and indeed that it can be done on assumed facts. That's disputed questions of law. I mention it only because obviously an implied term is part of the case. Disputed questions of fact obviously raise different considerations, and it's there where a court risks moving into mini-trial territory. But where a summary judgment application is listed for hearing, it would be wrong for a court simply to refuse to engage in a question of fact, where it's argued, as it was argued here, in some limited respects, that the claimant's case on the facts is bound to fail. And the court may be assisted in this regard by another authority, Calland and Financial Conduct Authority, which is in tab 6. The passage I show the court is in the judgment of Lord Justice Lewison. Begins at paragraph 28. And the judge is here critical of a failure to examine the raw materials said to amount to harassment. This was a case where an independent financial advisor claimed they'd been harassed by the Financial Conduct Authority. The fact that some factual or legal questions may be disputed does not absolve the judge from her duty to make an assessment of the claimant's prospects of success. As Lord Hobhouse put it in Three Rivers, the important words are no real prospect of succeeding. It requires the judge to undertake an exercise of judgment. He must decide whether to exercise the power to decide the case without a trial and give a summary judgment. It is a discretionary power, i.e. one where the choice whether to exercise the power lies within the jurisdiction of the judge. Secondly, he must carry out the necessary exercise of assessing the prospects of success of the relevant party. If he concludes there's no real prospect, he may decide the case accordingly. Whilst it must be remembered that the wood is composed of trees, some of which may need to be looked at individually, it's the assessment of the whole that is called for. A measure of analysis may be necessary, but the bottom line is ultimately what matters. And in evaluating the prospects of success, and sorry, to be clear, as you'll have seen, the emphasis in that passage was added by Lord Justice Lewison. In evaluating the prospects of success of a claim or defence, the judge is not required to abandon her critical faculties. And there's then the quotation from Lord Justice Potter in E.D. and F. Mann Liquid Products, which includes over the page, line 3, in some cases it may be clear that there is no real substance in factual assertions made, particularly if contradicted by contemporary documents. If so, issues which depend upon those factual assertions may be susceptible of disposal at an early stage, so as to save the cost and delay of trying an issue, the outcome of which is inevitable. The court was taken yesterday also to Kirieva and Bedshamov, paragraph 34. I wouldn't plan to go back to that. It's to the same effect, which is ordinarily you cannot reject evidence in a witness statement without cross-examination, but it's not an inflexible principle. It may in certain circumstances be open to the court to reject an untested piece of such evidence on the basis that it is manifestly incredible, either because it is inherently so, or because it's shown to be so by other facts that are admitted, or by reliable documents. And we don't dissent from that, because as we say, it reflects the trend which one sees here, that there are unusual cases where contemporaneous documents are sufficient to show that a piece of witness evidence has no real prospect of being accepted at trial. Now, the question of whether a factual dispute is reasonably arguable in this sense, whether the judge was therefore right to dispose of the dispute summarily, is as the passage from Lord Justice Lewison's judgment show, it's an evaluative question. The judge applies their critical faculties and reaches a judgment in respect of a legal test which is inherently imprecise. Whether a combination of contemporaneous documents is sufficient to demonstrate that there is no real substance to a party's evidence is a question on which, in some cases, reasonable judges might disagree. And as such, the question for the appeal court is whether the judge had legitimate and proper grounds for reaching the decision he did, rather than simply for the appeal court to approach the matter completely afresh and make up its own mind without regard to what the judge decided. And I have plagiarised that from Mr. Collins' skeleton at paragraph 5.2, where he cites the judgment of Lord Justice Sales in Smeck Properties and Runnymede. Equally, as it was put by Lord Justice Green in Kiefer Aislamientos, which I've almost certainly pronounced incorrectly, I know my lady and Lord Justice Davis agreed with this. Paragraph 95 of that judgment, which we have in the bundles, in a case involving a close evaluative exercise performed by the judge on the evidence, this court must exercise reticence in second-guessing that exercise. It's not open to an appellant to invite the court to re-perform the analysis of the evidence to see whether it agrees with the judge simply because the Court of Appeal is said to be in the same position as the High Court. Now, there is, of course, a tendency for any party who has had their claim summarily dismissed to cry foul and contend that there has been a mini-trial. But in my respectful submission, an appellant ought to be clear what that complaint entails. If the appellant is saying the judge decided legal questions incorrectly, that's not a mini-trial issue at all. That's a straightforward legal issue, and the appeal court can reconsider the legal issue for itself. If the appellant is saying the judge should not have evaluated the factual evidence at all, well, that's plainly wrong. The judge has a duty to evaluate factual evidence to the extent that it's contended that a factual claim made by the appellant is not reasonably arguable. If the appellant's saying the judge evaluated the facts but came to a conclusion we disagree with, then we say that the appellant should be explicit about which factual conclusion reached by the judge was one which was not open to him. How it made a difference to the judge's overall conclusion, and with respect, the Court of Appeal should then exercise reticence in considering whether the judge's evaluation was right or not. And if the appellant is saying something else, something along the lines of the judge should have waited for disclosure, well, then the appellant had better identify the topics on which disclosure could have made any difference. For example, in the present case, where MRL has its claim dismissed because on its own case it never sought consent to a sale, it cannot sensibly be argued that disclosure would make any difference. I make these points because ground 6 confuses these issues. We go back, please, to the grounds of appeal. Core Bundle 1, tab 1C, page 32. There is a generic complaint that the judge conducted, in effect, a mini-trial, and then 4 supposed consequences. My learned friend, Mr. Gledhill, charitably described these as wholly vague. The first is that in making findings which, the errors were in making findings which were not properly open to him to make in respect to the post-settlement agreement causes of action. No detail given. Then it said, in deciding that the claims against Lohomij for breach of Clause 6 and breach of Clause 9 were not reasonably arguable, again, no attempt to engage with the judge's reasons for rejecting those claims, to explain which part of that was a judgment that the court could not reach. Third, in deciding it wasn't reasonably arguable that Lohomij as a secured lender owed duties. That's a legal question. That is not a mini-trial question at all. And then fourth, in dismissing the amendment application, but that just followed from the conclusion that the claimant's claims were not arguable. Now, if there was substance to the mini-trial complaint, since it's not spelled out in the grounds of appeal, one might expect to see it spelled out in the skeleton. But it's not. Paragraph, the court will have the skeleton. It's in Core 1, Tab 2. The relevant passage begins at page 58. So paragraph 85 repeats the complaint set out above that there has been a mini-trial. And that cross-refers to paragraph 72. So if we could turn to that, please, that's at page 54. Paragraph 72(1) on page 54. The judge correctly summarised the approach which the court must adopt on an application for summary judgment. That's the claimant accepting that the judge correctly directed himself as to the law. Then we have the statement that the judge made crucial factual findings which cannot properly be made under the summary judgment test without identifying what those crucial factual findings might have been. And then we have the judge went so as far as to reject the evidence of the claimant's witnesses. But it's absolutely plain that a judge can reject evidence of witnesses, even when giving by practising solicitors. The question is whether, in this particular case, the judge erred in doing so, and there's no attempt to explain how the judge erred. More fundamentally, it is not generally true that the judge rejected the evidence of the claimant's witnesses. For the most part, where there are factual disputes, he notes that he cannot resolve them. I've shown the court paragraph 56, where the judge said he proceeded on the assumption that MRL's complaints concerning the conduct of the auction are correct. Can I just show the court other examples of this, please? At page 221 in the core bundle, paragraph 76, there's one other piece of narrative that, though disputed, is important for an understanding of how these proceedings have come about. The judge accepts that this is disputed, but he sets out nonetheless the evidence of Mr. Sullivan and Mr. Hilda. And he says at the end of this paragraph, for the purposes of this application, it's unnecessary to recite Mr. McLean's own account. Absolutely. Because the judge is assuming, for present purposes, that what was said by the claimant is correct. Paragraph 338 on page 338. This is in the context of Sale 2. One of the additional reasons given for rejecting Sale 2. And in the middle of this paragraph, that seems to me fairly implausible, though of itself it could not be determined without a trial. The judge was not willing to reject evidence on the ground that it was only fairly implausible. And with respect, that's absolutely right. That's the correct approach on a summary judgment application. Where the judge did reject elements of the claimant's evidence, he did so only by applying the high standard of incredibility or complete implausibility. So, for example, page 203, paragraph 41C, he describes in line 4 some evidence as being plainly wrong. And over the page, sorry, he also described it as simply incredible. There we are. Just over the page in the first line, simply incredible. That's the test that he is applying. And at paragraph 44, on this same issue, he describes MRL's case, 3 lines from the end, as making no sense on its own terms and incredible in light of the documents. Page 326, at paragraph 305. The inference, the judge says, right at the end of 305, that the alleged collapse of Sale 1 was due to Mr. Lauman's conduct was fanciful. On the same page, at paragraph 308. Fifth, the whole premise of MRL's case concerning interference in Sale 1 is fanciful, not to say absurd. Page 336. Paragraph 334. Middle of the paragraph, it's about 9 lines down, obviously incredible. Even this part of the case lacks credibility. And the same evidence is then described at 338, on page 338. At the end of 338, that's simply incredible, especially when taken together with the pretense of a threat of legal proceedings. MRL's case carries no conviction. Now, over and again, where the judge was rejecting MRL's case, it was not a balance of probabilities approach to weighing the evidence. It was only because MRL's case was, in the judge's judgment, incredible, utterly implausible, or absurd. And that's absolutely the right approach.
Just to be clear, the exercise you've just done, have you shown us all the cases where he rejected evidence?
I don't know. I haven't deliberately excluded any, but I can't say for sure.
What you've done is show us some where that was the test he applied, but you're not saying that that's all.
I can't say that for certain. I haven't seen any. I don't believe there are examples of him saying, on the balance of probabilities, I think this evidence is more likely than that evidence, and therefore I accept it. The judges obviously would not usually use extreme phrases of this sort. Normally, at the end of a trial, they just decide what happened on the balance of probabilities. The fact that the judge is repeatedly using these phrases, I say, shows that he well understood, that the correct process was to only reject evidence if he concluded that it met the summary judgment standard.
But for example, in that regard, what do you say to paragraph 306, which is was Mr. Schlup the meeting point? And that leads to one of the conclusions, doesn't it? That in relation to Cell 1, that the MRL's case is fanciful, if not absurd. Is there baked into these fanciful, absurd conclusions an impermissible approach to the evidence or not? I'm just using 306 as an
Absolutely.
example.
First of all, it's not an impermissible approach. The judge is asking himself the right questions. Second, it's not and I make it as a parenthesis, it's not a necessary finding to his conclusion. It's obviously quite important. This is part of the analysis on the amended particulars of claim, where the allegation is of a breach of an implied term. And if the judge is right, as we say, he is that there is no implied term, 306 goes nowhere anyway. I understand that the question is asked at the point of principle, though, so I'll deal with it at the point of principle. He was entirely satisfied, is the way he describes himself in the first words. Again, not a balance of probability approach. And it was described, this was one of the 2 cases taken against me, described as weighing up claimant's witnesses against defendant's witnesses. That's not what's happened here. It's not what's happened for two reasons. First, because there are contemporaneous documents. Those contemporaneous documents are not before the court, this court, because it was not a point taken in the skeleton that this is an example of something going wrong. So we don't have the underlying documents that the judge was looking at. But also, this is about whether Mr. Schlumpf made a statement at the 6th of July meeting or only at the 2nd of June meeting, whether he was only at the 2nd of June meeting. And what the judge had in mind here is that Mr. Sullivan's own evidence initially was it was the 2nd of June meeting. It was only later, when it became apparent that the 2nd of June meeting, if that was when it occurred, couldn't help the case, that Mr. Sullivan's evidence became the 6th of July. It's not just a conflict of evidence between claimant witnesses and defendant witnesses, it's between Mr. Sullivan and himself. Let me just show the court that, if I may. So if we go, please, in the pleading of the particulars of claim, tab 16, page 386. I've shown the court this passage. This continues to be the particulars of claim describing sale 1. And as I showed the court earlier, it describes a single meeting at which two events occur. First, Mr. Schlumpf makes statements about the money being due, and second, Mr. Laumann shouts over the speakerphone. We don't have the this isn't signed, I think, because it's a draft, but I can tell the courts that I've checked and the original particulars of claim were signed, were verified by Mr. Sullivan personally. Then we have the reply, and the reply is in tab 18.1 at page 666. And paragraph 54 says, to the best of MRL's knowledge, there were either 4 or 5 meetings. The events of 2 meetings are of particular relevance. The first substantive meeting took place on the 2nd of June. The material events of this meeting are set out at paragraph 71 to 73 of the particulars of claim. And those are the passages, I'm going to show you, before people jump up, I'm going to go to subparagraph 2 in a moment, but just focusing on subparagraph 1. The events that are said to have taken place on the 2nd of June are those set out in paragraph 71 to 73 of the particulars of claim, which includes Mr. Schlumpf's intervention. And again, these are verified by Mr. Sullivan. And these are the current versions of these documents. There's been no attempt to amend these and so on. It is currently said that Mr. Schlumpf, on the 2nd of June, intervened. It is somewhat oddly then pleaded at paragraph 54.2 that a further meeting took place on the 6th of July, and then Mr. Schlumpf's intervention is repleaded. It's a mess. But this is what the judge had. It wasn't as straightforward as one person's word against another. It was Mr. Sullivan's shifting word and contemporaneous documents which in the judge's judgment made it absolutely plain that Mr. Schlumpf was not at the meeting on the 6th of July. I think I've made the point. In any event, this particular incident, in a way it's a good example, because it shows the danger of this court attempting to delve into matters that the judge has evaluated in respect of unpleaded matters, because we don't have the underlying contemporaneous documents. But it's also an irrelevance, because as I've said, it only matters what happened on the 2nd of June or the 6th of July if the judge was also wrong on the implied term point. as my lady will have seen, paragraph 306 is, I think, third of 8 different reasons given by the judge in this respect. So we would say that even if the judge erred in this particular respect, which is a conclusion the court should be reticent to draw, but even if he did, it wouldn't make a difference to the overall outcome. Now, I should, since we're doing this, I should perhaps then deal with the other criticism, the pleaded one, or the one which is identified in the skeleton, which is at paragraph 86 of the skeleton. Which gives an example, the only example, of a specific complaint about the judge's course. And this is where, at paragraph 203 of the judgment, the judge quoted an email and commented that the email didn't actually accuse Lohomij, Mr. Schlumpf, or Mr. Laumann of having done anything to interfere with a proposed transaction. And 2 points I'd make about that. We can see the email itself is at page 286 of the judgment. The first point I'd make is the judge's comment on this email, or indeed the email itself, doesn't impact on the judge's stated conclusions as regards sale 1. This is an email which is in relation to sale 1. The judge hasn't found that Mr. Laumann didn't shout at someone on a speakerphone. He hasn't found what happened in fact. He simply comments that if what had happened is what they now say had happened, which is that Lohomij and Mr. Schlumpf and Mr. Laumann had been sabotaging sale 1, as it's put by MRL, then it's surprising that an email should be sent which doesn't make that point, but instead suggests that Mr. Laumann meeting with the FR group would actually help to bring sale 1 home. As I say though, this one example doesn't actually go anywhere. It certainly doesn't show that the judge had lost sight of the correct approach that he was supposed to take. And returning to the skeleton, the point that I'm dealt with, that I'm asked that I should deal with, Judge Holyfeld gave MRL's evidence the prominence and weight that it deserved. Again, we say that's simply a generic statement which isn't made out in the particular examples that are given. That's all I was proposing to say on the impermissible approach issue. We say the judge correctly directed himself as to the law. He exercised his judgment as he was required to do in evaluating the claimant's factual case against the contemporaneous documents. He was entitled to reject evidence where he concluded it was incredible against the standard, against the contemporaneous documents. And while 2 supposed errors have been identified, they're within his margin of evaluation. And in any event, they're not causative of any conclusion that the judge, that MRL can say was wrongly reached. My lady, that leaves the legal issue, which is essentially just the implied term. I don't think I'm going to be done within 5 minutes. I'm obviously.
How long will you be?
I shouldn't think I'll be more than 15 or 20 minutes.
Right, I'm just thinking about whether, given the strikes again tomorrow, whether it's worth trying to finish everything today, because Mr. Fenwick has half an hour as well. But I think that will take us on quite some time. It would be more like after 5 o'clock by the time we've finished. I think that's perhaps a little too late. And so on that basis, I think perhaps we'll leave the implied term until tomorrow morning, despite the fact that that leaves us with a small rump. But I think that everybody also needs to be able to get home on an evening before a strike day,
Yes.
including the court staff. And so perhaps it's better if we begin again tomorrow. Thank you very much indeed. And we will begin again at 10:30.
All right.